Seth Ornberg here with Professor Richard Epstein, the director of the Classical Liberal Institute, and we're here for our symposium on the moral philosophy of business law. So, Richard, what do you think of the conference so far, and what did you write for this?
Well, I think the conference does exactly what we are trying to do. Get people of all sorts of different perspectives, outlooks, backgrounds, and specialties, and have them talk about the fundamental problem of how moral is law and how law should be moral and whether it works. And I'm very pleased to see that we've had a bunch of papers that have pushed this very hard with a lot of constructive situation. What the Classical Liberal Institute specializes in is trying to have not only a general approach, but also to have enough institutional detail and understanding about particular cases so that the discussion just doesn't simply wander off into hopeless abstraction. My own paper was something that I started working on when I was a student at Oxford back in 1964. When do legal obligations start and when do moral or social obligations end? And what I tried to do is to develop a theory of reciprocity, which deals with very frequent high-level, low-level events, the small events, constant frequency, and if those take place, none of them get sued for, they all become essentially canceled out. And then what happens is if you get some big event, which is not offset, at that point you worry about legal enforcement. And it turns out the legal system with things like nuisance and so forth follows exactly the same pattern, so that the common criticism about imperfect moral obligations, that is, those not enforced by anything other than social convention or conscience, as being indeterminate and unformed, turns out to be wrong. They are very precisely understood by virtually everybody. Our job as an academic is to figure out why people know what to do and why they know how to do it right. And it turns out there's an important kind of element in all of these discussions, which is most people do things right by second nature, not by reflection. And it turns out the great advantage of that is it increases reliability, even if it turns out that it doesn't increase understanding. But for most people, they want to get the transaction right. As an academic, we're trying to look at it from the top and to figure out why it is they know more than they think they know in the way in which they behave. And so it's a combination of law and psychology. And it seems to me that's exactly what we're trying to do at the Classical Liberal Institute. Talk about all sorts of disciplines and see how, when you put them all together, they relate to law, oftentimes in very unexpected but very informative ways.
Thanks, Richard. And I had a question for you about contract law too,
Yeah.
because it seemed like you were making a statement that the common law gets consideration wrong. What's your argument about consideration and how this works with enforcement of some of these more imperfect obligations?
Well, what happens is the doctrine of consideration says that the only part of the world that you worried about are bargains in which there's something unperformed on both sides. The law of moral and social obligations is exactly the opposite. It tries to figure out how you deal with gratuitous arrangements and whether or not they have any legal implications, and if so, why. And the Romans were much better because they had a systematic way of looking at gratuitous obligations, and they didn't try to force feed it into the consideration model. And so even a simple contract, the mutum, which is I give you something in exchange for your giving it back, everybody understood these were low-level contracts. Sugar today, sugar back tomorrow. You could never enforce them in an executory fashion. So there wasn't consideration because there was no obligation to do it. But then once you delivered it, there was obviously an obligation to return the stuff. And for the most part, if it was small, you wouldn't even do that as a legal matter, but if it gets large, you can. But what happened is they drew a very clear distinction between the relatively small stakes in these contracts when there's no performance on our side, so you're only talking about lost profits, and the cases in which there's been asymmetrical performance, where one side has given something out and the other one has not, at which point enforcement becomes much more important, because the purpose of a good faith rule and an enforcement rule is to make sure that what goes to one side comes back to the other side so that there's rough parity in the obligation and it doesn't become a case of unjust enrichment or exploitation.
Richard, one last question for you. We're here behind the portrait of, this is a Louis Brandeis, and I want to ask you, is this statement true? Sunlight is the best disinfectant.
Well, it's one disinfectant, but remember, not only do we have sunlight, we also have medicines. And so the answer is it's a case of a little bit of an overgeneralization about what's going on, and Brandeis himself was a very complex figure. He wrote some of the best antitrust opinions in the world. He was the organizer of some of the most complicated vertical mergers in the world that worked. And he said some of the dumbest things in the history of Western civilization about big banks and why it is that they were exploitive. Like every great figure, they're not uniform. They have ups and they have downs. And what happens is when you look at them, it has to be one doctrine at a time. It cannot be you say, oh, I do or do not like Brandeis. But the neo-Brandeisians, for example, align themselves with his interventionist theory, and I regard for the most part as a very dangerous alternative to the classical liberal notion that what you're trying to do when you enforce the antitrust law is to prevent the abuses of monopolization and cartelization. What you're not trying to do is to reform the way in which manufacturing and other things start to take place. So in the pharmaceutical industry, just to take one example, our world's most uninformed president, Mr. Trump, has decided that the way in which you price pharmaceuticals is to require them to be sold in the United States at the lowest price they're sold everywhere else in the world. So one sale in Zambia for $100 means that you have to forego $10 billion of profits in the United States. It's a classic illustration of somebody who wants to have magic remedies but thinks he doesn't know anything about it.
Well, thank you, Richard. And thank you for being here at the conference. It's a pleasure. And let's get back to the panels.
By the way,